Good evening, everyone. I, I am CA Kamal Jain, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by a Continuing Professional Education Committee of ICI. It is my pleasure to be a moderator for the webinar on professional opportunity for CAs under RERA and succession planning. In a short while, we will start this webinar. First, I would like to apprise you about CPE committee. In today's ever-changing professional scenario worldwide, the biggest challenge the professional face is how to stay on the top of their game while adapting to new requirements and norms. Therefore, it is imperative to aim to be up to date to offer unique guidance, influence others with their innovative approach and expertise. It is also vital to stretch old ideas beyond traditional boundaries to create new perspectives. In this context, continuing professional education facilities professionals to maintain, improve, and broaden their knowledge, skills, and expertise required to achieve their professional goals through the webinar and seminar, etc. The program for this evening is as follows. We have two sessions of 1 hour each, and topics are professional opportunities for chartered accountant under RERA, succession planning. Our eminent speaker will talk about mention two emerging areas of professional interest. Friends, our first session is on RERA, for which we requested to our eminent speaker, C.S. Sunil Damodar Naik. Sunil Damodar Naik, sir, is there. Sir, good evening.
Namaste.
Sir, Sunil Damodar Naik, sir, I want to introduce Sunil, sir. He has over 4 decades of professional experience in taxation, audit, and advisory and specialized in RERA consultancy, handling project registrations, compliances, and advisory for major real estate development. He holds professional qualification in CA, CWA, and CS, and has achieved all India ranks in the both chartered accountancy and company secretary examinations. He has delivered multiple sessions on RERA and tax matters across various platforms. Sir, we welcomes you.
Thank you so much. It's a pleasure.
Sir, now I would like to request you, please deliberate your session and enlighten us.
Okay, thank you. Let me share this screen for you. Good afternoon to all. Sincere thanks to the organizers for giving me this opportunity to deliberate on this subject. A subject which is very close to my heart. I've been practicing for the last 42 years of my life, but last 6 years I've been into this RERA practice on a full-time basis. Am I audible properly?
Yes, sir. Yes, sir.
Great. Okay. So now the topic given to me is professional opportunities for chartered accountants under RERA. So this is an emerging profession, and being in the profession on a full-time basis, I consider that my other friends also should think about this vertical as a part of their professional practice. And enough money is available there, enough work is available there. So there is a potential for any chartered accountant to take up RERA as a vertical, if not as a full-time practice. So what are the opportunities here that are in front of us? I'll just deliberate on that. I've been given 1 hour's time. I take about 55 minutes or 50 minutes to give my presentation. Any questions will be welcome after the session is over. So I start now. This RERA Act basically is an act which is of the central government. It extends to whole of India, and wherein the states have been given the liberty to notify rules and regulations. So this act for Maharashtra, where I belong to, the government has formed its own rules and regulations, and it came into effect from 1st of May 2017. So here the opportunity opened on that particular day for all of us, and I, being more risk prone or ready to take risk, I thought it is a right opportunity for me to take a plunge, and I stopped my traditional practice, and now I am full-time RERA consultant. So that can give you an idea that after almost 35 years of practice, a CA who is well settled in practice takes this decision to leave his traditionally set practice and start a new venture. So that is the potential of this act. Going further, first you have to understand what the law is, because why the law came into force. Because all over India, we had multiple laws which were covering real estate, but this law was considered necessary in that situation by the Modi government. And when Venkaiah Naidu was the housing minister at the center, he proposed this bill in the parliament. He had given his speech, and wherein he said that this law is required to achieve the following objectives. So he mentioned the objectives which are required to be delivered by this law. It said, ensure accountability towards allottees and protect their interests, which indicates that this is a law which is a consumer friendly law. It is a law brought in for the benefit of the allottees. 98% of the law favors the allottees, and there is hardly 2% left for the developer on his side. So this is a law, one has to understand, this is a consumer welfare legislation. So the law will always like to protect the allottees. Then it says infuse transparency, because this trade, the real estate, never had the transparency. You had always the situation of a developer using money of A project for purchasing B project land, or taking away the money, or their bank defaults. There are multiple things happening in the real estate because it was an unorganized industry. So to take care of that, this law has come into play. Then it says introduce professionalism, which means that this law takes into account the professionals like architects, advocates, chartered accountants, engineers to implement the law. Then it said we want a pan-India standardization, which means that a person from Mumbai can take the liberty under this law to buy a property somewhere in Chandigarh without worrying much about the law, because the law is standardized. What is applicable to Maharashtra will be applicable to even Chandigarh, and he can be comfortable there. Then it said establish symmetry of information, which means that the promoter and allottee talk the same language. The data as required by the allottee is available to the allottee while taking the decision about investment into a project. Then it says there are responsibilities cast upon the promoter as well as the allottees under the law. Then it said we'll have a regulatory oversight mechanism. So RERA is a body like SEBI which oversees the entire operations of the real estate industry. Then it said there was a necessity of having a resolution mechanism which will be fast track. The courts take years together to resolve a dispute. So for the disputes in the real estate industry, the law said that we will put up a separate mechanism, a legal mechanism for as an authority or as a tribunal to hear the disputes of the industry and find quick solutions to these problems. And the end of it, promote good governance. Because if you see the law is Real Estate Regulation and Development Act. The development word is silent. The D is not captured in the short form of RERA. So the law wants that everybody should be disciplined, and in the process, the real estate industry is developed in the interest of all the beneficiaries. Now, let us look at who are the beneficiaries of this trade. So, the important players of this industry: promoter, co-promoter, landowner, society as landowner, investor in real estate, a mortgager in real estate, a project financer, a contractor under barter arrangement, allottees, and real estate agents. All these people are your potential clients. For a chartered accountant, all of these gentlemen are going to require your services, and for that, you should be ready to deliver the services in the best interest of your client. So we'll go step by step of each of these real estate player to understand what services they expect from our profession. Then the law, this may be the only law in the country wherein the implementation is done through a team of professionals. The RERA Act is to be implemented by taking the services of professionals like architects, engineer, chartered accountant, advocate, and a banker holding RERA account. So all these people are made accountable by law, by RERA, to provide services to their clients, but to give information as may be required in the interest of the allottees as well as the trade as a whole. So these people are again your potential clients because they will require your services in the future when they come across RERA and they have issues wherein they don't have a solution. You are the right person as a chartered accountant to offer a solution to all these people. So now let us go next step when we try to understand what exactly is the opportunity for a chartered accountant. Now let us take the first most important player, which is the promoter or the co-promoter. In normal parlance, we say he is the developer. So for a developer under RERA, there are multiple obligations cast upon him. The chapter on functions and duties of promoters establishes all the responsibilities on the head of the promoter, how he is supposed to behave while delivering a real estate project to a potential allottee. Now, the first and foremost thing, what starts the process is the registration of the project. So here, the services of a chartered accountant are required because while doing the registration, one form number 3 has to be submitted by the promoter to RERA. And that form is a form wherein the signature of the chartered accountant as well as the promoter is required to be given. Here, the CA comes into play because there are multiple forms to be filled in, lot of information to be compiled, collated, and to be submitted to the authority for registration. So this is the first and foremost thing which initiates the RERA process, and you are the right person to be at the right time, at the right place to give the services required for completing the registration. Now, friends, here I'd like to tell you one important thing. Normally, in the real estate, the architect and the engineer were the people who were the revenue side, which means that they were instrumental in creating a project. The project emerges out of the plans as prepared by the architect, the structural designs as prepared by the engineer. So these two people were always on the revenue side of the promoter, which means that when a project is supposed to be conceived, these two professionals were instrumental in creating that project. So when that process was completed, after that the CA came into picture, and the CA as always one minute, there's some issue here. Hello.
Yes, sir, you are on.
I think the screen there is some issue. 1 minute, I'll just try it out again. No, but it is being shared. What the issue is? 1 minute. Yes. Let me continue. I got this piece of paper, no issues. So what happens is that the promoter at that point in time, when the bills are raised by the professionals, the first thing what comes to the mind of the promoter is that the engineer and the architect are the people who are on the revenue side. Their bills have to be cleared at the earliest. But the bill raised by the chartered accountant will always remain on the back burner because the chartered accountant there is on the expenditure side. Here today under RERA, we are on the income side because we are the people who issue a certificate for registration. So unless the CA issues the certificate for registration, the registration does not happen, which means that here the chartered accountant gets a very much importance. So he is the right guy at the right place to issue the certificate. So friends, when you decide to go for RERA practice, the potential of getting money faster and easier is much more than the traditional practice. Going further, the chartered accountant is required to do compliances on a regular basis. There is a concept of a quarterly progress report, the QPR. The CA is required to issue a certificate in form number 3 every quarter for the benefit of the promoter. Unless that is submitted to RERA, the banker of the project will not permit any withdrawals from the project. So again, the CA becomes very important. Unless he issues the certificate, there is no way that the client can get money out of his bank account. So here again the CA becomes of paramount importance because he is the right person who is supposed to give the correct information to RERA. Going further, there is an annual certificate in form number 5. It is required to be given by a chartered accountant for the client who is the promoter of the unit. Going further, then the requirements of income tax, GST come into play, wherein the CA is required to deliver the returns and other things for the client. Next is the litigation under RERA. So what happens is under RERA, the litigation is to be taken up by advocates or even by chartered accountants. Here, a chartered accountant is permitted under the law to take up litigation at both the levels, which is at the authority level as well as at the tribunal level. Further, for a project financing is one more area wherein a chartered accountant is in a position to deliver the best results for the client. Next, we go ahead for the society formation, which is required to be formed under the law. The conveyance is to be given by the developer to the society of the allottees. There is an obligation cast upon the developer under the law of RERA. Okay. Then the one more area which is available to us is escrow custody, which means that the documents which are executed between the developer and all the other agencies may be kept under escrow for a certain period of time till the deliverables are delivered by the concerned person. Herein again a chartered accountant can be relied upon by the promoter and by the allottees also for the purpose of keeping any documents under escrow. Then we go to the important decision about creating an entity when a promoter desires of taking a project, then he has to decide the entity under which he is going to do that. It is going to be a partnership or a LLP or a company or an individual account, whatever it may be. That decision is required to be taken in the interest of the client by the chartered accountant. So for a promoter, he is your client. He is going to give you a lot of work. There is a potential right from the inception of the project till the completion, when at each and every level a chartered accountant is required to deliver for the client. Especially Form 3 is a certificate to be issued by the chartered accountant to the RERA authority, and Form 5, which is the annual certificate to be issued by the chartered accountant to the RERA authority. So all these are the requirements under the law for a promoter and which are to be complied with by a chartered accountant. So for you as a chartered accountant, all these areas are opening up and there is a potential for any chartered accountant to take up these verticals in the interest of the profession. Going further, there is an opportunity for a CA to deal with the landowner also.
Yes, sir. Sir, your PPT is not showing.
Sir, your PPT is not visible.
Not visible. I don't know why, but I'll just check it out 1 minute.
Can you try to share the screen again, sir? It
One
seems
minute.
it switched to Zoom, sir.
Now this.
It is currently on Zoom. Can you change it to the presentation?
I'll just try to 1 minute.
Recording in progress. Recording in progress. Recording in progress.
No, dear. Okay, I'll continue with this, no issues. I can tell you what exactly I'm sharing with you. Then you come to the landowner, wherein there can be arrangement of area sharing with the developer. There can be arrangement of revenue sharing with the developer. Now here a CA comes into play because there's a lot of documentation to be done with the owner as well as with the developer. Then for that purpose, you have to create all the documentation in the interest of both the parties. Then we go ahead with the family arrangement because there can be a situation that there is a landowner who is having a family and the family wants an internal distribution. So then again, we as chartered accountants are required to deliver the exact expected result of the landowner. Herein the landowner may ask you to do estate planning, may ask you to form a family arrangement, document that, wherein you are required to indicate to them what are the tax implications, whether it is income tax or GST. So all this, because we are the people who understand RERA, who understand income tax, who understand GST. We are the right people to give the right answer to the client in the interest of the client. So in both the arrangements, whether it's area sharing or revenue sharing, the chartered accountant is the right person who can give the right advice to the people. In case of revenue sharing under RERA, the landowner also is termed as a promoter. So all the responsibilities cast upon a promoter under RERA are cast upon the landowner also. So here, if you have a landowner as a client, you have to perform all the obligations as expected from you under RERA so that he is compliant and his bank accounts are operated in a given fashion. The RERA mechanism says that 70% of the collection made from the allottees has to be utilized for the purpose of the project and there is no liberty granted for diversion of funds. Here, you have to educate your client, whether he is the promoter or the landowner, to make sure that he delivers and he performs financial discipline as expected out of him. Going further, in case of society as a landowner, what happens is, especially in Mumbai and Maharashtra, we have the concept of a housing society. When the society is formed of the members, society is the owner of the land. So in case the society is going for redevelopment, in that case, again, a chartered accountant is required. The society can be your potential client, wherein your services will be required to draft the joint development agreement, which is the agreement which confers the rights of development from the society to the land, to the developer. Herein, that agreement has to be drafted very meticulously in the interest of the society so that the society gets all the commitments made by the developer in time and in the manner it has been agreed upon. Now here, there can be situations that the FSI or the FAR what you call in north, is right now available maybe 1.1. It increases over a period of time. How to account for that? Who gets the benefit of that FAR or FSI in the future? How it has to be shared? How it has to be allocated? Who is going to spend for creation of the FSI? Who is going to spend the money to get the approvals in place? All that has to be factored when you enter the joint development agreement. So friends, as a chartered accountant, we have to examine these laws, understand the commercial part of the entire transaction, make sure that the society who is your client is benefited to the utmost in the process of joint development. Then with the society comes their members. So there is a two-way thing. It is a society as a whole and the members individual also. There are tax implications for the society as well as the members in their individual capacity when they're going to get the flats. How does income tax affect them? How does GST affect them? How does the RERA affect them? What are the rights to the individual allottees as well as society under RERA in case of default of the developer? All these questions, you are the only right person who can give the right answers. So if you are a RERA practitioner, you should be learning this law to understand all these situations and create solutions for these questions which may come to you in the future. Then there are investors in the real estate trade, people who invest money at some stage in the project and they want to exit the project at an opportune time after making some money out of the project. These are the people who are making money. They are not the allottees. They are not interested in retaining the property for a long period of time, but they want to make their money by investing at the right time and living at the right time. Now, if an investor happens to be your client, then you have to create a documentation by way of investor agreement to get documentation for a power of attorney in case the project fructifies. The investor wants to sell the property. What is the mechanism of the sale? How he can effect the sales? What is the best way forward for him in time to come? Again, the implication of tax are bound to be there. The income tax will be applicable on the transaction. So how to protect the client so that the income tax incidence is properly managed by you is again your forte. GST comes into play in case you are going to show sale and purchase. The stamp duty is going to come into play where in case you are going to show sale and purchase. So all these things are the areas wherein the investor is going to require your advice and your services. Going further, in case there is a mortgager, somebody has already given money for a piece of land, the land is proposed to be developed. The mortgager comes to you as a client and tells you, look, help me out under RERA, how I am protected. So there, again, the documentation, the mortgage document, the power of attorney for effecting sales in the future. In case of default, what is the way forward? What is the tax applicability? What is the GST applicability? All these areas, you are the right person who can advise the client about how to proceed in the matter, how to get these services and get proper tax advice as regards GST as well as income tax. Plus, how this transaction can be taken up under RERA so that the protection as offered by RERA is available to the mortgager also, which means that you have to factor this into account that whether the protection as given to the allottees can be expanded to cover the mortgager. If yes, what is the way forward? What document will protect the mortgager and make him an allottee so that in future he can approach RERA for any grievances in case he has some. Then we go to the next player in the market, which is the project financer. It can be a banker or an NBFC. So those bankers or the NBFCs who finance the real estate, they are your clients because they want to understand from you as a professional how the project is performing. So you should be in a position to access all the information as available on RERA portal of a client, of a project, understand the financial discipline by the promoter, whether the money given by the financer, the project financer, is utilized for the right purpose or not, whether there is a diversion of funds, whether the funds are siphoned off, how best the project financer is being taken care of by the developer, whether the developer, whatever commitments he has given vis-a-vis the project financer and allottees, how well he is performing. You are the person who is going to give the red signal or raise the red flags to the project financer in case something is going wrong. So before any tranche is being delivered by the project financer to the promoter, it is right time for the project financer to approach a chartered accountant to understand RERA, to take his opinion how best the project financer is being secured or not. So this is the area again, you as a chartered accountant can be in a position to advise the project financer how to structure his financing arrangements. So here the potential is while granting finance. Secondly, during the course of the financing structure over a period of time of the project, and then closure of the transaction, and the project finance has to go back to the project financer. So how to implement that? At what stage? How the interest of the financer is being taken care of or not? What securities are to be attached or mortgaged or taken into custody or even effected into sell to monetize the debt and make sure that the project financer, yeah, yeah, I can't help it. I'm not going to do that. Send it to share. Actually, in case you can share it, that will be great. Because I tried that, but it's not working here. So I'm reading from the presentation. It is the same screen slide. I got a printed copy with me, which I'm reading out of that. Now, this is a problem. I'll just try once again, but I can't do it. I told Shreyas about this, and he told me that, okay, I'll manage that, but I think he's not available right now. 1 minute. I'll just try once again, in case I can make it. Yeah, I opened that. 1 minute. Let's try once again. Wait. Yeah, I opened it. Wait. Yeah. Yes, correct. Perfect. Okay, so I'll go further. Yeah. Okay. Investor, mortgager, right. Project financer. Yeah, we're here. So here, the documentation for project financing is the core of the transaction. Here, as a chartered accountant, you should be in a position to analyze the project, understand the dynamics, and give the best advice to your client, who is the financer. Then you have to factor that in case of default, how your client is protected. Then the income tax applicability and GST applicability, which means that you have to make sure that the income tax and GST is not impacted on your transaction, because that may result in a total loss or a partial loss to the project financer. And then for you as a chartered accountant, it is your duty to make sure that all the updates which are visible on the RERA portal about the project are seen by you also from time to time, so that you can advise the client in case you find there is something wrong going on in the project. You can raise a red flag at the appropriate time before the project comes into more difficulties. Here, as a watchdog of the project financer, you can be acting in the interest of the project financer. You'll make sure that the project runs smoothly, the finances are properly deployed in the interest of the project, and there is no loss happening to the project financer, who is your client. Then a contractor under barter arrangement. This is a practice which is prevalent more in Mumbai, wherein the contractor is offered some area by the developer. Now here, in case the contractor is offered the area with the arrangement to sell the property on his own, in that case, the contractor also gets the character of a promoter. So in that case, the documentation for barter arrangement, again, the skill of a chartered accountant, because he has to factor the income tax, the GST applicability in all that. So under barter arrangement, if you are dealing on behalf of the contractor, you have to make sure that at the landmark stage and each and every milestone stage, your client is being taken care of. He is not being deprived of his entitlements by the promoter. So the document should speak for itself. Then in many cases, what happens is that there are disputes and litigations about the quality of service rendered, quality of product designed by the contractor. Some problems here and there may occur. So you have to factor on behalf of your client how these disputes and litigations can be avoided. And in case they come into existence, how best your client is protected. That is the area where, again, as a chartered accountant, it is your paramount duty to make sure that your client is being protected under all the relevant laws, and whether the protection under RERA can be obtained by the contractor in case of a difficult situation. Then now the most important person of the trade for whom the whole thing is structured is the allottee. Allottee in normal case or normal parlance is the purchaser of the property. All of us have purchased properties during our lifetime, and all of us, if you think in hindsight, we always had a very bitter experience about the developer. So it is universal that the developers have been not that great delivery boys. They have been always lagging in the delivery on a time scale or doing some mischief in the transaction. So this law of RERA is basically to take care of these allottees. So for the allottees now, in case you are representing the allottee, first and foremost thing, what you have to help the allottees, whether you can look into the project which is visible on the RERA website, so that you can give the allottee the right information, wherein he can take a decision which is well thought of, which is well reasoned, and which is in the interest of the allottee. So you, as a chartered accountant, can browse the website of RERA and come to a conclusion in the interest of the client, whether it is the right project to invest, whether the promoter has been delivering in time, delivering properly, how many complaints are visible on the RERA website, whether his performance is up to the mark. RERA expects a promoter to give the information about the past projects delivered by the promoter. So by examining those projects, you as a chartered accountant can understand what sort of a performance the developer has been giving in the past, and whether he will continue to give it in the future. You get carried away by the names of the developers who may not be exactly the same persons who have the reputation. We have got families in Mumbai wherein they have been really great developers, but the offsprings and the cousins and other people who have come after them, who carry the same surname but do not deliver the same product. So it is your duty to educate your client with an allottee about the project, about the promoters, and then enable him to take a decision in the interest, so that his investment does not go waste. The product that he expects is delivered to him in the right manner. Now, what are documentation which come into play here? First, the letter of allotment. You have to make sure the letter of allotment is in the format as given by RERA. The format has been prescribed, and the changes, if any, required to be made are subject to the approval of RERA authority. Same way, the agreement to sell. We have got this practice wherein you are just instructed by the promoter to go to the registration office and sign without seeing any documents. That is bygone. Now, the RERA expects the developer to submit all the documents for the information of the allottee. And the allottee, after verifying the documents, is supposed to finalize the transaction, which means that as an allottee now, there is a right given under RERA to each one of us to verify all the documents and make sure the documents are in the right manner and they are in the right way. The expectation of the law is being taken care of. In the possession letter, again, you used to have a possession letter without reading anything mentioned there. You were just made to sign on the dotted line on the last page. Again, that is by one. The letter of allotment, the agreement to sale, and a possession letter drafts are required to uploaded on the website of RERA so that they are visible to everybody. Now, you as a chartered accountant can be the right person to analyze all these documents and make sure the interest of your client, who is the allottee, is being protected in the right manner. So protection under RERA is of paramount importance. You as an allottee or a representative should look into the protection under RERA, which is given in the law, and make sure that you have all the possible protection under the law. Then the complaint filing. We as chartered accountants are permitted to file the complaint on behalf of the promoter or the allottee, as the case may be, with the RERA authority. We are allowed to represent the allottee and the promoter in front of a RERA authority. So the jobs that advocates used to do, now we are legally permitted under the law to do that. Now, friends, here I would like to say that the advocates have the practice of raising the bill the moment the service is delivered. And in case you happen to fail to pay the advocate the past bill, for the next hearing, he doesn't appear. He is not available for you to render you services. This is the traditional way of the advocates. For we as chartered accountants, we have never followed this practice in the whole of our history. So here under RERA, the practitioners are basically advocates, and now we are entering that field. So let us follow the same tradition of the advocates. Raise the bill the moment the services are rendered, and the client, because he is disciplined by the advocates to pay the bills in time, he will pay you also. I can tell you from my experience that the bills are paid regularly by the client because he wants your services in the future also. Same way, we as chartered accountants are allowed to file complaint with the RERA tribunal and defend the complaints also. So you can be attending the RERA tribunal as a chartered accountant and defending your promoter or defend your allottee, as the case may be. So here there is a new scope developed for us in practice, wherein the litigation, which is not our forte so far, but honestly, we can fight litigation much better than all other professionals, basically because we have the habit and we have been trained by the institute that you should take a 360-degree view of any subject, understand the subject in detail, and get ready. So when we as chartered accountants do the litigation, we are ready with the entire arguments till the very end, which is not the case with the advocates. They have a system of handling that case on that particular day only. We as chartered accountants are trained. What we do is that we try to understand the whole matter and get the ultimate delivery for the client in his interest. So wherein we can easily we can be having an advantage of better knowledge than the advocates. And mark my words, the authorities also, whether it is the authority or the tribunal, they give a lot of respect to chartered accountants who do litigation at their level. So as a litigant, a chartered accountant is well respected by the authority and the tribunal. So this is the area where again we have a tremendous potential of giving services to the real estate fraternity. Then real estate agents. Agents also are required to get training to qualify under RERA. Their registration is compulsory. Their compliance are compulsory. All these three things we as chartered accountants are required to give services to the agents also to make sure that they are compliant under the law. Now, the next step, which is the most important step, you can have a promoter as your client, you can have a allottee as your client, you can have a contractor as your client, you can have architect as your client, because the architect concerned may be handling a RERA project on his own and he doesn't understand accounts. So he wants your services to give him the exact information about the project, the accounting part of it, the financial part of it. So your architect can be your potential client who will require your services in time to come, so that he is in a position to deliver the best service to his client on the other side. Same is the case with the engineer. The engineer may be knowing his part of the engineering consultancy very well, but when he has to do something in RERA, he may require some financial information which is available with us as chartered accountants. Same case with the advocate. Advocate who is practicing RERA will require the services of a chartered accountant who is practicing RERA, so that he is in a position to give the title report in the right manner. For drafting of a document, the advocate will require the services of a chartered accountant to understand the dynamics of the project in a better manner. Then the banker holding RERA account. Under RERA, a banker is being instructed to maintain the RERA account in a given fashion. There are bankers who are not well conversant with the RERA provisions and they require our services. I have been interacting with few banks wherein they request my services to operate a RERA account. So what is exactly the law, how the account is to be operated, what is to be done, what is not to be done, what is the compliance expected by a banker. All this is to be done by a chartered accountant. So here again, we as chartered accountants are the people who can give you all the correct information. Friends, this is a law which has come into existence, honestly speaking, for our fraternity, because the architects who give the certificates give certificates of the visual things that they see on the site. They will certify the building as it stands there. They may say, okay, 4 slabs are constructed and brickwork is in progress. So they are comfortable, but they are seeing what they are certifying. The engineer is certifying his opinion. He is given estimate. He is also not into difficulties. But we as chartered accountants are issuing a certificate. A certificate is a statement of facts. It is not the opinion. We are expected to verify the facts and certify the facts for the RERA authority to monitor the progress of a project. So for us, when we give any certificate, we are bound to the project. So friends, the RERA work is very good, is very paying, but it is equally carrying a lot of risk while issuing a certificate. So I will request my dear friend Vishnu Agarwal to have a session on Form 3 and Form 5, which is a certificate to be issued by a chartered accountant under RERA, and then educate all our professional fraternity about the exact concept of Form 3 and Form 5, what exactly is expected out of that Form 3 and Form 5 by the RERA authority, and how to make sure that you are not unnecessarily certifying something which does not exist or which is not correct. So friends, all this potential is available to you under RERA. I am available as a full-time chartered accountant into RERA practice who can give you assistance, guidance, whatever required at the appropriate level. The work is really nicely paying and it can take you much further. You need not take the risk the way I have taken to be a full-time RERA consultant, but you can create a vertical in your office where RERA also can be an area of your practice. With this, I thank you so much for the patient hearing. Thank you, Jain Saab, for giving me
Thank
the
you, sir. Thank you. Thank you, sir.
Any
Sir,
questions?
there are some questions from participants.
Yeah, tell me.
First question is a land measuring 6 acres is owned by 5% jointly.
Okay.
But there is a land measuring 6 acres owned by 5% jointly.
Okay.
Not any firm or AOP. Matlab, they are holding
Co-ownership.
personally.
Co-ownership, okay.
They want to sell by plotting, not as developer is RERA registration required.
Yes. See, any project wherein the performance is going to be futuristic. For example, these 6 people or 5 people who are the owners, they are going to complete the project by putting up roads there, putting up gutters there, putting compound walls there, dividing the property, getting a layout sanction. All these are the efforts required to convert that piece of land into plots for sale. This is activity of development of the property. And herein, because you are going to deliver the product to an allottee on a futuristic basis, you are required to get a project registration. Give in that whatever obligation you are taking upon yourself as a developer, and then deliver the product to the allottees. So these gentlemen, 5 or 6, whatever case may be, will have to go in for a joint registration as co-owners and get the project registered under RERA, and they will have to perform all the discipline as contemplated under the law.
Thank you, sir. Second question is that one participant is asking, sir, dear sir, I have read the RERA where it says that within 5 years of possession, the builder has to correct all the structural damages. Is it true?
Yes, it is true. And there was a High Court judgment. Hello. The law says that the developer is bound to rectify all the structural damages or a lack of workmanship by the developer, so that the allottee is not put to any inconvenience. The law says the allottee has to file a complaint with the developer, and within 21 days of filing the complaint, developer should rectify the mistake or rectify the damage and make sure that the allottee is not put to any inconvenience. Of late, there was a case wherein the High Court, Bombay High Court, said that that period of 5 years also is indicative in nature, and it can be extended in case of poor workmanship by the developer. So this is an obligation cast upon the developer, and nowadays agreement to sell, which is drafted under RERA, takes care of this issue, because there is a specific provision in that the developer agrees to perform the obligation of rectifying the structural defects in a span of 5 years. So this is obligatory, this is not optional.
Okay, sir.
Yeah.
Same participant is also asking, is water leakage is covered also?
Yes, it depends on what sort of a leakage is coming into your play. Because if it is a leakage coming from some outside window, it may not be included. But a structural defect, like for example, if your terrace is leaking because you have not done the waterproofing correctly, then yes, that also will be covered, and you have to rectify that for a period of 5 years from the date of possession.
Okay, sir. Thank you so much, sir. And sir, another participating is asking, what is the minimum value of project to comply RERA?
There is a minimum value. There is
Yes.
a condition of 500 square meter of plot or 8 allottees, 8 units to be constructed. If you
Okay.
fall under that, then registration is required. There is no value limit as such. If your
Okay.
plot size is more than 500 meters, or if your number of units is more than 8, the registration is compulsory.
Okay, sir. And he's also asking, what is the penalty for the developer if there is a delay, and what is the CA role on the certification?
See it like this. There is a interest to be paid in case of delay in giving possession, from the date of the promised date of possession till the date of actual possession with OC. For that period, the allottee is entitled to claim interest from the developer. In case the allottee, the project is not taking shape and the allottee opts for refund after the delay, then from the date of payment of the money by the allottee to the developer till the date of refund by the developer to the allottee, there is an interest liability on the developer. The penalties are exigible only in case of a default by the promoter to perform. Penalties have been imposed of late in Maharashtra for non-performance, not filing of QPR. There are penalties being levied, but the law has been still being quite lenient. Penalties have not been imposed right, left, and center. There have been monetary penalties, not on the basis of percentage of the value of the project. If you see the law says the penalties can be levied as a percentage of the cost of the project, which is a very enormous amount of money, but that has not been put into operation by the authority. They are imposing value-wise penalties. like
Okay.
50,000, 1 lakh rupees they impose. And in case you can contend properly and convince them that we are compliant, then the penalties are dropped also.
Okay, sir.
Yeah.
One more question is there, sir. Very much interesting question. How one participant is asking, how can we start initially? Shall we pitch the bankers or developer? How can we acquire client base?
No, this is you see, it is not that you have to acquire something. You have to be first understanding the law very carefully, having a good knowledge of the law. Then once you have the good knowledge of the law, you start interacting with the players in the real estate. You may start with the agent, you may start with the authority, you may start with the promoter or contractor. But if you know the law well, and if you can educate the concerned person that you have the good knowledge of the law, the person is bound to come back to you. I have been giving presentation to societies who have come back to me after 3 years, after the presentation over. So that I invested in time, spent time with those people, tried to impart whatever knowledge I have got to them. And when the issue comes on their table, they recollect that there is somebody by this name who had come to give us knowledge about this subject. So the client is not there in the market ready waiting for you. You have to go and develop your own knowledge of the subject, and then your knowledge will get to the clients. It is a Saraswati which will come first, followed by Lakshmi.
And
Not the
then
other way around. So it has to be your patience, investment in time, investment in this sort of a lectures, imparting lectures to people, giving knowledge, writing something, because I was instrumental in writing the book on the RERA of the Maharashtra government. You have to invest in time there, and then automatically, smoothly, the work will start coming to you.
100%.
It's not going to happen overnight. It is going to happen, but over a period of time. Yeah.
Very true, sir. So there are many questions, but because of limitation of time, sir, we cannot take all questions. Thank you so much, sir. You are artful. Thank you, and sharing such valuable insight on RERA. Your practical approach truly simplified. Am I audible?
Yes.
Sir, sorry for technical. I'm audible?
Yes, sir.
Hello.
Yes, sir.
Sir, we are going to start, friends, second session of this webinar. We have a eminent speaker, CA Tanuj Agrawal ji from Jaipur itself. Sir, Tanuj Agrawal ji is there? Tanuj Agrawal ji is there?
He is here. He is here.
Yes, sir, I am here.
Okay, sir. I want to give some introduction about the Tanuj Agrawal ji, Advocate Tanuj Agrawal ji. He is an experienced legal professional specializing in litigation related to direct and indirect taxation as well corporate law across all appellate forums up to the Honorable Supreme Court of India. He holds multiple professional and academic qualifications, LLB, BCom, CA, CS, CMA, along with All India third rank in CMA final and fifth rank in CMA intermediate. He is also given multiple sessions and frequent speaker at professional seminars and webinars where he shares expertise on taxation, business, and inheritance laws. Sir, we are waiting for our succession planning So we want to listen you on succession planning, sir. We welcomes you, Tarun Bhaiya.
Thank you very much, CA Kamal Jain ji, my younger brother from my own city, Pink City. And I am also thankful to the Institute of Chartered Accountants of India for providing me this opportunity to interact with my fellow colleagues of CAs. And I am also thankful to CA Satish Kumar Gupta ji, Chairman CPE Committee, Central Council member. Is my presentation visible?
Yes, visible, Bhaiya.
Okay. Just a second.
Just do the full screen, sir. Presentation.
Yes, I have done full screen.
Thanks.
So there are ample opportunities for chartered accountants in this succession planning. As a chartered accountant, we don't have the succession laws in our curriculum. But let me tell you, as a chartered accountant, I practiced 11 years, and thereafter, since last 10 years, I am practicing as an advocate. And I foresee huge professional opportunities. The first and foremost reason is that in case of audits, which is a core domain of a chartered accountant in practice, there are some limitations. The first limitation is of deadline. Whereas in case of succession planning, there is no deadline. After your audit season is over and you are comparatively free, you can study this law and you can pursue your own clients. The second benefit, you don't have to take new clients. You can work on your existing clientage. The third important thing is you can charge extra amount of money. Money is no limit, because for audit, as my earlier speaker CA Sunil ji said, audit is treated as an expense by a businessman. But succession planning will not be treated as an expense. It will rather be treated as an income or investment which will yield aggressive returns. Let me share you a short story to understand what succession planning is. One lady, she was married in old time. It is a case of old time. In 1955, she was married, and soon after her marriage, within 3 months, her husband unfortunately expired. And thereafter, her in-laws, her husband relatives, kicked her out of the family and of his husband house. She came back to her maternal parents' house, where her maternal family, her own parents supported her, and they motivated her to pursue higher education and thereafter pursue job. She did well in education as well as job. 41 years passed away. Meanwhile, she earned a good amount of income in her bank accounts and also created assets. But unfortunately, she expired after 41 years of marriage. She was not having any child out of the previous wedlock, and she didn't take any legal divorce or any legal separation because her husband had expired, and she also didn't do a second marriage. So what happened after her death, after 41 years? Her mother and her family, her maternal family, they claimed her assets. But after 41 years, her husband relatives also came in picture, and she also claimed her assets. Matter went up to the court, and it was decided by the Honorable Supreme Court, the apex court of the country, that the assets will go to the husband legal heirs. Maybe in 41 years of long period, she has not even visited. She has not even seen. She not even remember who were the relatives. And that relatives of husband who kicked her out of her family house, of her husband house. But unfortunately, what has happened? Because Supreme Court is bound by the law. So the decision came in favor of the husband relatives and against the maternal relatives. So this is very unfortunate because of lack of succession planning. So let's begin our presentation. What is the biggest truth of life? The biggest truth is death. Future is always uncertain. You cannot foresee what will happen tomorrow, after an hour, after a month. Future is always uncertain. कल हो ना हो, किसी को नहीं मालूम. The recent example is of COVID-19, the pandemic, where the families vanished. Lot of deaths came across the world. So we plan everything. We plan our vacations, we plan our business, our family investments. But what we don't plan our succession. If we don't plan our succession, what will happen? Disputes will arise between our legal heirs as well as our outsiders. Our business operation will collapse. There will be loss of investments, maybe partial or total. And our legal heirs, our loved ones, our family, our children, they will face huge complications in transfer and transmission of assets and investments. So it is always better to do succession planning when you are alive. And for chartered accountants, it is very important to do succession plannings of your clients for the benefit of the clients and for your benefit as well, because this will open a vertical field in your practice area. What is succession? The legal definition of succession, if we see, it is transmission of rights as well as assets and obligations of a person to his or her legal heirs on his or her death. There are two main options with regard to succession. As we all know, the first option is where there is no will. This in technical terms we call as intestate succession. And the second option is where there is a will. This is in technical terms testamentary succession. We will discuss both these successions in detail here and after in the slides to come. So this is the master slide of succession. Religion is, we say all are one. Religion is one. But succession is an exception to this. Because to which religion you belong, different succession laws will apply. Article 44 Uniform Civil Code is not there in picture till now. So there are different succession laws for different persons. In case there is no will, that is intestate succession. If you are a Hindu, Jain, Sikh or Buddhist, the Hindu succession at 1956 will apply. If you are a Christian, Parsi or Jew, and there is no will, Indian succession at 1925 will apply. In case of Muslims, the Muslim law, the Shariat law will apply. And in case there is a will, then for Muslims, the Shariat law, Muslim law applies, and to all other except Muslims, be it Hindu, Jain, Sikh, Buddhist, Christian, Parsi or Jew, the provisions of Indian Succession Act 1925 will apply. So which is the right option? Whether to make a will or to leave everything on destiny? Let's discuss some case studies. Case study number 1. Here a person, a male, 28 years of age, he was recently married. He dies leaving behind his father. His mother has already expired. And he had a younger unmarried sister and wife. We are presuming in all these case studies that a person belongs to Hindu, Jain, Buddhist or Sikh religion. So we are discussing here the Hindu Succession Act 1956. So in this case study, Mr. A expires and these are 3 legal years. And he has some assets including huge insurance policies in which his father is a nominee. So the answer of this query I am not giving. This I will give after we have discussed the Hindu Succession Act 1956. I am just posing this question to the August gathering that they can analyze what will be the answer in their mind. So we can discuss this afterwards. I am just posing the questions here. The case study number 2. A widow. She is a Buddhist woman. She dies leaving behind her 23 years old son, who is a drug addict. Her old father-in-law and mother-in-law, senior citizens of age. So where the property will go? Where all the assets of this widow will go? Let's see. There is no will. Case study number 3. A millionaire couple dies in a road accident, leaving behind mother of the husband, minor daughter, and brother of the husband. Brother is a notorious person living separately from the family. And what happens? Hearing the unfortunate tragic news, mother also dies. Case study number 4. This is the case study which I discussed with you in my opening remarks. Narayana Devi, her husband died within 3 months of marriage in 1955. She was thrown out of her husband's home by her husband relatives. She came back to her paternal home where she was supported in terms of finance, education, job, etc. She earned well and after 41 years she expired, leaving good assets after post-marriage. And she was survived by her mother and brothers and her husband relatives. Where all her assets will go? Let's discuss that. Case study number 5. Mr. A, 28 years of age, he takes mutual divorce from his first wife, who was pregnant at that time of divorce. And all the assets and all the liabilities and all things were settled through huge one-time alimony. His wife agrees to take custody of to-be-born child for lifetime. Now this person, Mr. A, remarries another woman whose husband has already expired and she was having a male child around 1 year old from a previous husband, which was very well accepted by Mr. A. Mr. A thereafter lived happily, but after 50 years he expired, leaving behind his stepchild and his family. And after his death, his child from first wife appears after 50 years and he claims Mr. A as a son. So what will be the picture in this case? Let's discuss that. Before giving answers to the case studies, all the 5 case studies, let's discuss in detail the provisions of the Hindu Succession Act 1956 in case of interstate succession where there is no will. So there are different provisions for Hindu male and Hindu female. When I am using the term Hindu, I include Jain, Sikhs and Buddhist. So in case of a Hindu male, if he dies interstate, the property will go to class 1 heirs. All his assets and liabilities will go to class 1 heirs. If there are no class 1 heirs, then the property will go to class 2 heirs. Who are class 1 heirs and who are class 2 heirs? This will be discussed in detail in the slide to come. So if there are no class 1 heirs and if there are no class 2 heirs, then the property will go to agnates. Agnates are the relatives from father's side. If there are no class 1 heirs, there are no class 2 heirs, there are no agnates, then the property will go to cognates, who are the relatives of mother's side. And if all of the above category is not present, then the entire property will go to the government of India. In case of male, who are class 1 heirs? It is widow of the deceased male, mother, sons and daughters. Interesting thing here is father is not there in the definition of class 1 heirs. Maybe at the time when 1956 the act came into force, at that time father was having good assets. Because father was capable at that time, family was joint. But nowadays situation has changed. So who are class 1 here in case of a male? Widow, mother, sons and daughters. Please note there is no distinction between whether daughter is married, unmarried, minor, major, earning well or not earning well, dependent, independent. There is no such distinction. And what is the share here? Equal share. For example, if a person is survived by his widow, means wife, as well 1 son and 1 daughter. So the equal share will be 3 because there will be 3 class 1 heirs. Widow as well as 1 child, 1 male child and 1 female child, 1 son and 1 daughter. If there is only mother and only widow left, there are no children, then 50-50. 50% to widow and 50% to mother. If there is 1 widow and 4 children, then 25%, 20% each, 1/5 each. 1 share to widow and 20% share to each child. I think it is clear. So who are the other class 1 heirs? For example, if a son has already predeceased the male person, then the lower category, then the family, the class 1 heirs of son will be taken into account. But together they will get 1 share. For example, if there is a death of a person and he was having 1 wife as well as 1 child, and his child has family, uski wife bhi thi and he has 1 child. So the ratio will be 50% to wife and 50% to son. But his son has already expired, leaving behind his son's wife as well as son's child, mean his grandchild. So between the son's wife as well as between the son's child, there will be again 50-50. Meaning thereby his widow will get 50%, son's widow will get 25%, and son's child, means his grandchild, will get 25%. So this is all about class 1 heirs. If there is Section 8 of Hindu Succession Act 1956 says, if there are more than one widow, then all widows will take one share. And surviving sons and daughters and mother will take one share each. This we have already discussed. Now coming to class 2 heirs. Class 2 heirs will get share only when there is no class 1 heir left in the family. If there are class 1 heirs, then the entire share of the property, all assets will go to class 1 heirs. But if there are no class 2 heirs, then the property will go to whom? Class 2 heirs. And the first is father. If father is alive and there are no class 1 heirs, the entire assets will go to father. And if father is not there, then second class, which is son's daughter, son, son's daughter, daughter, brother and sister. Siblings are there. And each category, the distribution will be equal. For example, if there is one son's daughter, one daughter, and one brother and one sister, there will be equal distribution. And if second category is not there, then to third category. If third category is not there, then to fourth category. If fourth category is not there, then to fifth, then to sixth. See, grandfather and grandparents, grandfather, grandmother, they are in fifth category. So this is the category. And thereafter it is father's brother, mean Tauji or Chacha, uncle or Buaji or aunt. So in this ratio, in this category, the entire assets will be divided. I repeat, if there are no class 1 heirs, and then the property will go to class 2 heirs in this sequence. If father is there, entire to father. If father is not there, then to next. Then if no there is in next category, then to next. I hope it is clear. If there are no class 1 heirs and no class 2 heirs, then to agnates. These agnates are the person related by blood through males, father relatives. For example, father's brother son means your cousin, Tauji ka ladka, Chacha ka ladka. And if there are no class 1 heirs, no class 2 heirs, no agnates, then to cognates, who are relative to your mother side, meaning thereby your maternal cousin, mama ka ladka, mama ka ladki, and so on. And if all persons are not there, no class 1 heirs, no class 2 heirs, no agnates, no cognates, then the entire assets will go to the government. Now there are some important points here. Stepson. Stepson means Sotela beta. Previous marriage son. Child born from previous marriage of your spouse. These are not class 1 heirs. Honorable Bombay High Court, Honorable Punjab and Haryana High Court, and Honorable Delhi High Court all have held that stepson is not a class 1 heirs because he was born from the wedlock of earlier marriage, from earlier spouse. He is class 1 heirs of his earlier marriage, earlier parents, but not class 1 heir of second parent, who is not his natural parent. Then in case of adoption, adoption child is treated as a class 1 heir, provided that all the compliances of Section 12 of the Hindu Adoption and Maintenance Act 1956 are duly complied with. If it is legally and duly adopted under the law, adopted child is a class 1 heir. So children from divorced parent are class 1 heirs because they are your natural born children. Even if the divorced partner alimony and maintenance is settled, even if you are not having custody of your child, even then, divorced parent children are class 1 heirs. Illegitimate child, if born out of wedlock, then these are treated as class 1 heirs. Honorable Supreme Court in a recent judgment of Revana Siddappa versus Maleka Arjun, Justice CJI Mr. D.Y. Chandrachud, this was order of him, and he held a child born in illegitimate relationship, void marriage, is innocent and is entitled to all rights which are given to other children born in valid marriage. So illegitimate children are also treated as class 1 years. And child in womb, unborn child. Section 20 of Hindu Succession Act 1956 provides that child in womb has also a right, provided that he or she is born alive after the death of the person. Now, in case of females, Hindu females, provisions are slightly different. Section 15(1) says that in case of a death of a Hindu female, the entire property will go to her children, sons, daughters, and husband. If these are alive, all the entire assets will go to these persons in equal ratio. But if this category is not there, then the entire property will go to heirs of the husband. If there are no children, no husband left, no heirs of husband left, then to mother and father. If all three, the first three categories are not there, then to heirs of father. And if the first four are not there, then to heirs of mother. Order of succession will be, and earlier entry will be preferred over to the subsequent entry. There is one exception, section 15(2) of the Hindu Succession Act, which says if the property of a female is inherited from her parents and she dies without children, then the property will revert back to his father's heirs. And if the property is inherited from husband's side, then the property will go to her husband's heirs if there are no children. So this is one exception to the general rule. In case of female intestate succession, all the property, whether acquired by her, self-acquired, before marriage, after marriage, movable, immovable, stridhan, maintenance through a skill, through gift, partition, or any property, this shall be treated his or her property, absolute property, for the purpose of Hindu Succession Act. Now, we have discussed the provisions of Hindu Succession Act in case of intestate succession for both male as well as female. In case of when there is no will, so which is the right option, whether to make a will or to don't make a will. If we don't make a will, the provisions of Hindu Succession Act will apply and the law will take over. And if there is a will, the provisions of Indian Succession Act 1925 will apply, and the choice of the testator or testatrix, meaning thereby the choice of the person making the will prevail over the law. Now let's go back to our case studies. In case study number 1, one person, Mr. A, he was recently married, he expired, leaving behind his father, mother has already expired, younger unmarried sister and wife. Now the entire property will go to his wife, not to his father, because father is class 2 years. Father is not there in class 1 year list. And not to his younger unmarried sister, because sister is also in class 2 years list. So if we perceive, how unfortunate thing is this? The father, younger unmarried sister, who were dependent on his son or brother respectively, they will not get any share. And wife, the entire life is there before the wife. What she will do? She may remarry and settle, but the entire assets of Mr. A will go to his wife. Father as well as unmarried sister will not get a single penny. Even in case of nominations in assets or insurance policies, in bank accounts or lockers, anywhere, if name of father is there, then also the entire property will go to wife. Because nominee is merely a custodian. Father has to hand over all the assets to the ultimate owner as per law, which is wife, and father is merely a custodian. Custodian is an agent, not an owner. Law will prevail here. I hope it is clear, and now we come back to case study number 2. In this case, a female expires. Her husband has already died, leaving behind his 23 years old son, father-in-law, mother-in-law. Now the entire assets will go to the 23 years old son, because father-in-law and mother-in-law are not there. Above his children and husband. Since his husband is already expired, now the entire property will go to her 23-year-old son. Maybe she has inherited the property from her deceased husband. Now the parents of the husband, that is his father-in-law and mother-in-law, will not get anything at age of 80 and 75 years because of no succession planning. The law is clear. The third case study is a millionaire couple expires in a road accident, leaving behind his mother, minor daughter, brother of husband, and mother. Thereafter, hearing the news, she also dies. Now, in this case, if the couple has expired, the entire property will go to mother of the husband, 50%, and daughter, because mother and children, these are class 1 years. 50% will go to mother and 50% will go to minor daughter. But hearing the unfortunate news, mother also expires, and mother also do not have any will. So then, who are the now legal heirs of mother? Brother of the husband, meaning the son of mother, the other son, the second son, who is a notorious person, and her granddaughter, daughter of her predeceased son. So 25% of the 50% of the share of mother which she got, out of that half will go to the minor daughter, means her granddaughter, and half will go to the brother of the husband, meaning thereby his son. So in overall, 75% of the property will go to minor daughter, and 75 and remaining 25% will go to brother of the husband. Now there is undivided share. Even if there is a house, there is a factory or any asset, her brother will claim, I am owner of 25% of the house. I am owner of 25% of the factory. But disputes will arise. Case study number 4. This we have already discussed. And see, this is the case of Om Prakash Vardhi Radha Charan 2009 15 SCC 66 Supreme Court. His Lordship, Mr. Justice S.B. Sinha, what he wrote in para number 10, it is pertinent to note here. This is a hard case. Nairani during her lifetime did not visit her in-laws' place. We will presume that the contention raised by Mr. Chaudhary is the counsel for the appellant, counsel from the relatives of the deceased wife, that she had not been lent any support from her husband family is correct, and all support had come from her parents. But then only because a case appears to be hard would not lead us to invoke different interpretation of a statutory provision which is otherwise impermissible. It is now a settled principle of law that sentiment or sympathy alone would not be a guiding factor in determining the rights of the parties which are otherwise clear and unambiguous. Meaning thereby, the entire property will go to the heirs of the husband who kicked her out of her husband home, who didn't take care of her in the past 41 years, and her relatives who supported her. Her own relatives from her father, mother, brother, and sister, they will not get anything. And this is a life example of a poor succession planning. Unfortunate, because the law take over here. We as professionals, we as chartered accountants, advocate, have to first inculcate the habit of succession planning in our own family, maybe close family or extended family, and thereafter we should also do this for our clients. Now, case study number 5. In this case, Mr. A has taken mutual divorce from his wife. He was having one to-be-born child, and all alimony, all assets were settled. And thereafter, he remarries another woman who was already having a male child. Presently, at that time, was 1 year old, and after 50 years, he expires. Now, his earlier child from earlier marriage, whom he has not seen in 50 years, will get the entire assets because of the succession laws. His stepchild, who was taking care of her, and maybe he was around 1 year of old at that time, and he was not having that knowledge that he is not my real father, he is not my natural father. But he will not get any share because stepchild is not a class 1 years. And even a child from a divorced parent, since he or she is a natural born child, he is a class 1 year. Now, there are some limitations of interstate succession, which we have already discussed. There will be disputes between legal heirs. Or even if earlier there were no disputes will arise. Family will collapse. The law will take over. law makes no distinction between worthy son and unworthy son. Deserving relatives such as grandparents, they may get neglected, and undeserving may enjoy. Undue advantage are also taken by third parties like tenants and partners. What the tenants say? You first resolve your disputes between your family and thereafter let us know, we will pay the rent to whom. And what happens? The family is fighting. I will take the rent. I am the owner of this property. Outsiders, the third parties enjoy. And huge cost, time, and energy of your family, your children are wasted in transmission of assets because of huge complications involved. And there is a possibility of a notice assets also, because the person who has died has not disclosed about the assets of to her wife or a spouse or family. There may be some foreign asset that may get unnoticed, some foreign business. And there may be some cross ownership of assets, some joint ownership. This will also create problem. And what happens? Family ultimately sell these assets at a cheaper price, at a much lower price because of the disputes, and the other parties enjoy. What will happen to the business? The business will also hamper. Now, succession planning. It is an old saying about planning is failing to plan means planning to fail. Like we plan each and everything, our retirement, vacations, investment, we should also plan our succession for ourselves and also plan succession for our clients, which is a good business vertical here. We should not leave everything on law. Let our own choice prevail and wisdom prevail. One golden rule I am sharing here: anticipate it today and review on every birthday. Meaning thereby you should anticipate that today, if I die and today there is no will, where the property will go, where my assets will go, who will enjoy, who are class 1 years, whether there are any class 1 years or the property will go to class 2 years. This is important, particularly when mother is not there and father is there, because mother, since she is a class 1 relative, but she is not there, father is not in the category of class 1 relative. He is a class 2 relative. So in any case, if mother is not there, we should be very cautious. We should make will, we should plan our succession to help our family, to help our children, to help our loved ones after we leave the world. Now, this was all about intestate succession. We are coming to testamentary succession, where there is a will. Section 2H of Indian Succession Act 1925 defines will as a legal declaration of intention of a testator. Testator is a person who is making the will with respect to his property, which he desired to be carried into effect after his death. In simple terms, it is just an intention. After his death or her death, where he or she wants his assets to go and in which proportion. There are some terms in testamentary succession like testator. He is a person who is making the will. In case of a female person, it is testatrix. And executor and administrator, it is a person who is appointed by the testator to carry out the terms of her will. Meaning thereby the executor or a administrator will take care of the will after his or her death. Beneficiary is the person who is named as beneficiary in the will, who will get the assets on the death. Codicil, it is just like an amendment, a supplementary deed, like we make a supplementary partnership deed. Codicil is just where a term or where a part of a will is changed. So it is in the form of codicil. Now, what are the steps in making a will? The first step is drafting. Drafting is very important. Here we have to be cautious. One, ambiguity and disputes will arise. The second step is appointing any executor. Third is signing, including thumb mark at all pages with date and before two independent witnesses. Who can be an executor? Even chartered accountants can be an executor, for which they may charge fees. And they may also help in drafting of will and execution of will. And who can be a witness, that we will discuss in detail in the slides to come. then safe custody of the will is necessary, that it is in safe hands and it is unearthed timely after the death. If a will is remained unnoticed after the expiry of person, then it is of no use. So safe custody is very important. Though registration of a will is not mandatory, but it is always recommended that it should be registered with sub-registrar. Now, who can make a will? Any person above 18 years of age can make a will. Maybe a female, male, married, unmarried, having good health, not good health. He should be of sound mind. He should not be a subject matter of fraud or under any undue influence or coercion. Will should be voluntary and he should know the contents of the will. Even a deaf and dumb person, a blind person, he can also make a will, provided that all the contents of the will are duly explained to him or her. In case of an insane person means जिसको थोड़ा mental disturbance आता है थोड़ा timing for temporary period. So during the period of sanity, when he is okay, his mental state is okay and good, he can make a will, provided that a doctor is witness. Otherwise, the will be challenged. Now, who should make a will? In my opinion, each and every person, whether business, professional, male, female, married, unmarried, young, old, a family having cordial relation or disputed family relation, they should make a will. In case of matrimonial disputes, you should make a will. Rich, poor, each and every one person should make a will. Where there is only child, people say, I have only one child, why should I make a will? But there are many complications involved. So will should be made by each and every person. I don't have any immovable property, why should I make a will? No, it is for movable assets also. Who can be a beneficiary? Your any member, whether class 1, class 2, agnates, cognates, any relative can be a beneficiary to your will. Even your friend can be a beneficiary. Even your servant can be a beneficiary to some extent. Trust. You can donate some amount to trust, some of your assets to trust or make a trust. So you can specify in the will. Even a stranger can be a beneficiary. Pet. Pet can also be a beneficiary. Stranger in case of ma'am Priyamada Birla, she made her chartered accountant as beneficiary. Now, what can be the subject matter of will? Any property, whether movable, immovable, intellectual property rights, self-acquired, received in partition, received through gifts, inheritance in individual capacity, HUF property, only your share. The entire HUF property you cannot bequeath through a will. You cannot include that in will because HUF is a separate other than individual. Other people have also right. Other family member have rights in your HUF property. So only for your share in your HUF property, you can make a will. Your business, you can make a will that after my business, my son number 1 or son number 2 or wife, who will be the owner. And that thing should also be mentioned in the will and so also be disclosed to your chartered accountant or your consultant who is looking after your business. Unrevealed assets, some assets may be there which the family members are not knowing. For example, some foreign assets or some assets in some city, other city. So that assets can also be disclosed in the will. Digital assets, lockers, future assets, you can mention your future assets also, current and future liabilities, and even the cremation procedure. Okay, I want to donate my body to such and such trust for public welfare. And I want to donate my eyes. That thing can also be mentioned in the will. Donation and charities, if you want to donate some amount to some trust, some person, you can mention in the will. What cannot be subject matter of will? Tenancy rights. If you are tenant somewhere, then you cannot say after my death, my son will take over as a tenant. No, since tenancy rights are not transferable. In case of partners, in partnership firm, if you are a partner in a partnership firm, you cannot mention after me, my son or my wife will become partner automatically. No, for that the consent of other partners is also required. If this is the case, it is advisable that presently during your lifetime in your partnership deed with the consent of all partners, you should make an amendment in case of my death, my my such and such person, my wife or my children, they will become partner to the extent of my shares. When you are alive, your other partners will agree. Once this clause is not there in the partnership deed, then disputes will arise. Positions and posts in organization, I am secretary, I am president somewhere, that cannot be treated. That cannot be written in will. That is not part of will. So drafting of a will. Drafting of a will is very important where a chartered accountant can play a good role. First thing is testator details. The personal details of the person has to be mentioned in detail here. Then the competency clause, that he is of free mind, good health, good mental health, and is not under any fraud, not under any undue influence. That thing has to be mentioned in the will. Then all the details of closed family members and relative detail has to be mentioned in the will. Next come is the asset liability detail. Details of all assets, movable, immovable, digital, present, future, all liabilities that have to be mentioned in detail in the will. Then the beneficiary details has to be mentioned. That to whom which asset will go to whom after the death. This thing has to be clearly drafted. If you are giving something to person and not giving something to person, you should clearly mention. For example, if a person is giving the entire assets to one child, and not to other child, he should clearly mention here. Otherwise, dispute will arise. Then who will be the executor, administrator of the will? Maybe a chartered accountant, lawyer, or any relative. So details of executor should be there. And one clause should be there, all past will should be are revoked. And this is my last will, and I have cancelled all and revoked all my past will. This clause should be there. And will should be made in detail. And utmost care should be exercised while drafting a will. A small error will lead to many disputes. Who can be a witness to a will? Any independent witness. Witness should not be a beneficiary. It should be known to the testator and his family. It is generally recommended one doctor and one legal professional or chartered accountant can be a beneficiary to a will, provided that he is competent to contract, above 18 years of age, and of unsound mind. One important thing here is that the witness should not necessarily know the contents of the will. He is just a witness to the fact that the person making the will has signed in his presence on the will. And he was not under any coercion, undue influence of fraud or gunpoint. So this is the job of the witness only. He doesn't ought to know the contents of the will. Who can be an executor to a will? And one important thing I think I forgot to mention this point, the beneficiary to the will should not be a witness. Witness should be independent. Who can be executor to a will? Any person known to a testator. Again, same thing, above 18 years of age. Even a beneficiary can be executor to a will. And chartered accountant also can be a beneficiary, can be executor to a will. More than one executor can also be appointed, joint executors. Just like in CA, we appoint joint auditors. And if there are no executor appointed, then the executor has to be appointed through court. So it's better to mention name of the executor in the will. Registration of will, as I already said, it is not compulsory, but it is highly recommended. It should be registered before sub-registrar because the authenticity of the will increases, as well as the chances of future disputes after the death are mitigated. So therefore, registration of a will is though not compulsory, but it is highly recommended. And it also eases in transmission and transfer of assets. A registered will is readily accepted by the government departments, by banks, by registrar, by your future potential buyers of property. If will is registered, then you have to go to other options of probate, etc. Can will be on a plan paper? Yes, why not? Stamp paper is not mandatory and it can be handwritten also. When will comes into effect? Only when the testator dies. Till the testator is alive, he remains the owner of his all assets. And he can change his will anytime. only at the time of his death, the beneficiary comes into picture, not before that. What if the beneficiary mentioned in the will predeceases the testator? For example, the entire property goes to his child, but his child has already expired. What will happen? Now the heirs of his child will get the property. For example, in case of a predeceased son, wife of a predeceased son, children of predeceased son, and class 1 years of predeceased son, they will get the entire property. Life interest. This life interest is very important. Sometimes what happens, a person is named in the will as a beneficiary, but not as owner. This generally happens in case of spouse. Till I am alive, I am the owner of my house, but after my death, my spouse, my wife, will have life interest over this property. She can enjoy this property, she can live, she can lease out, but she cannot sell. And after her death only, my son will get this property and he will get selling right. So this is an example of life interest. Drafting has to be done very carefully and all the situation has to be envisaged very properly. Otherwise, this life interest clause will prove catastrophic and it will prove fatal. One case I will like to share with you all. It is Sadhu Singh versus Gurudwara Sahib Singh Narike. In this case, husband gave life interest to his wife. That wife will enjoy my property after my death. And after the death of my wife, it will go to my nephews, who will be the real owner. Now, what happened? The person expired and the wife donated that property to Gurudwara because they were not, husband and wife were not having any children. They were having only nephews. Now, wife donated it to Gurudwara. Then the nephews took the case to the courts and the matter reached to the Honorable Supreme Court, wherein the Honorable Supreme Court held in favor of the nephews because they held since she was not having absolute rights over the property and she was only having life interest, she was not allowed to donate it to Gurudwara. And the real beneficiaries, the real owners of that property will be the nephews. Can separate will be made for separate assets? Yes. Why not? For example, if a person is having 3 immovable properties and 2 sons, so he decides my son A will get property A, my son B will get property B, and for property C, I am not yet decided. I will decide it later on. So what he can do, he can make separate will for this A and B, but for the other property, which he has not yet decided, he can make a will afterwards. But this fact has to be clearly mentioned in the will, in both the wills, in the future will as well as the present will. Otherwise, the will may be challenged and due to ambiguity. So separate wills can be made for separate assets. Revocation of will by testator's marriage. In case of other than Hindus, Sikhs, Jain, Buddhists, like Christian, Jews, and Parsis, Section 69 of Indian Succession Act 1925 applies, which says if a will is made before marriage, then due to marriage, the will is automatically revoked. The will is cancelled. And the person has to make fresh will due to his marriage. But this is not a case in case of Hindus, Jains, Sikhs, Buddhists, or Muslims. So Section 69 of Indian Succession Act 1925 does not come here. A probate. In case of Chennai, Kolkata, and Mumbai, a probate has to be taken from court. What is a probate? Probate is a certified copy of will obtained from a court. It is not mandatory in Rajasthan, but in other states, I mentioned Chennai, Kolkata, Mumbai, it is necessary to take probate. And letter of administration, in case of no will, in case of interstate succession, court has to be approached and letter of administration has to be taken that who are the legal heirs of the deceased. Public notice is given, there are some formalities to be complied with, and thereafter the court issues letter of administration. In some state, it is known as succession certificate. These are one and the same thing, where list of legal heirs is given, value of estate is given, death certificate is given. And thereafter on depositing certain court fees which differ from state to state, as this is a state subject, succession certificate is issued by the court. Now, nomination. It is very important to have nominations in all your assets. Nowadays you can also fix percentage nomination. Please note that nominee is only a custodian. Nominee is not the real owner. Real owner is only the person in case of interstate succession, which is the succession laws will provide, like Hindu Succession Act, class 1 years or class 2 years. And in case of testamentary succession, where there is a will, the person, the beneficiary mentioned in the will be the real owner, not the nominee. But nomination should be there, and if the nominee has already expired, nomination should be updated as soon as possible. Joint owner. There may be a case where one property is held in joint name. So in case of joint property, if any person wants to make a will, then he can make will of his share only, his or her share only, not the entire property. And there are three types of joint holders or nomination, which we can discuss later on. Joint will, yes. Husband and wife can make joint will that after the death of the husband, the wife will get all the properties. And after the death of wife, husband will get all the property, which is reciprocal promises. And after death of both the person, the children will go get the properties. Joint will can be there is no harm, but there is one important thing to be kept in mind here is, in case of a joint will, it cannot be revised, amended after the death of one person. So take care of this. If there is a need of revising will or making a new will, cancelling or revoking the earlier will, then joint will is not advisable in such cases. The liability of leaguer here is limited only to the extent of the assets or property received through inheritance. For example, if a person is a beneficiary is getting 1 crore rupees from decease of the assets, of his assets through will, and liability is 10 crore. So the legally is not liable to pay to the extent beyond 1 crore rupees. HUF is a good tool for tax planning. Generally, immovable property is not advisable because HUF is a fluctuating body. Every time when a person is born, he or she, the child, becomes member of the HUF, and in case of a death, then the share of a death is reduced. Then it is a fluctuating body. And even daughters are also now, with effect from 9/9/2005, they are also having right in HUF property. Since the time is about to get over, I am rushing because I have few more slides to come. So as I already said, with effect from 9/9/2005, daughters have equal right at par with son. Maybe daughter is minor or major, maybe married, maybe unmarried. And Honorable Supreme Court, three-judge bench, in the case of Vinita Sharma versus Rakesh Sharma, they said daughter must be alive on 9/9/2005. Father may or may not be alive. And HUF must exist on 9/9/2005. Settled issues, they said, will remain settled. So meaning thereby, what is the crux of this matter? Even daughters are having share after 9/9/2005 in the HUF of their father. Private trust, yes. In case trust is a good part of a good form of tax planning. Particularly when the children is incapable. Then through trust can be created and the assets of deceased can be transferred through trust for the benefit of the beneficiaries. Now, there are several benefits of making a will, that is testamentary succession. The first benefit is the person making a will can distribute his or assets as per his or her own wish. Even the deserving beneficiaries like grandparents, father, and grandchildren or siblings, they are not in the class 1 years list. So other than class 1 years, class 2 years can also be made a beneficiary. And the interstate law provisions, they are kept on hold once there is a will. Assets are revealed. Interest of female senior citizens are protected. A will allows a testator to donate his or her assets after his or death. The business flourishes. Liabilities are taken care of. And the children, your loved ones, your family, they are not involved into much hassles of transmission of assets and liabilities after death. Because a will is a document, and if it is registered, it is a more authentic document through which you can transfer or transmit your assets to your family. And will is also a good part of tax planning. Through will, you can give to your son's wife, which otherwise cannot be given due to clubbing provisions of Section 64. And through will, you can give your assets to HUF of your son. Otherwise, it is covered under Section 56. So tax planning, will is also a part of good tax planning, and chartered accountants here can play a very important role. In case of small business, you should ask your clients, in case any unfortunate incident, your death happens, who will be your beneficiary of your proprietorship. Similarly, in case of say of HF, who will be Karta? Similarly, in case of partnership, LLPs, now who will be inducted in your partnership firm in your place? In case of private limited, what will be about shareholdings, directorship, each and everything chartered accountant can discuss with their clients and can incorporate in will. In case of large business, there are general problems of cross-holding of assets, cross-holding of personal properties, and cross-holding of shareholdings. So these things can be very well taken care of, either during the lifetime or through will. So there are some real examples of good succession planning, like Birla Group, Bhushan Group. And forget about these examples. There are many real life examples around us, maybe in our family, maybe in our extended family, our friends' family, or our client's family, which we can perceive. Without proper succession planning, their disputes have arisen between the family members, business has hampered, and there are no talking relations between the family members as of now, which when the person was alive were very cordial. The business was running very smoothly, and thereafter, what has happened to the business? The children are fighting. Outsiders, tenants are enjoying, partners are enjoying, other people are enjoying. At the cost of whom? At the cost of the family members. Now, I told this earlier also, anticipate your debt today and review on every birthday. This is the golden rule. That's why I've used golden font here. Will should be made early. Not that when I will retire at the age of 60 years or when my health is not there with me, then I will make will. No, you can make will today of yours, your family, of your client. Maybe if a need arises, you can revise it, you can revoke it and make a fresh will later on. But why to wait? Practical tip is go for registration of will, as I discussed in detail earlier, and take guidance of your family members in making a will. This, however, depends upon facts and circumstances of the case. If the relation are cordial, you may take guidance. If you think relation will hamper, then you may not take guidance. And you may disclose the contents of the will or provide a Xerox copy thereof to your beneficiaries. But this is again with the rider. It depends upon the facts and circumstances of the family. You should share your assets with your spouse so that nothing is unrevealed. And your spouse, in case of any unfortunate event, your spouse is very well aware of where you are partner, what are your sources of income, where you have bank account, where you have lockers, and all your assets. You should share your username, password, and important documents with your spouse. Maybe you can keep one file there and ask your spouse to open it only at the time of any unfortunate event, so that she gets access to username, passwords, maybe your email or some important documents. And the family member, your spouse, is not head to mouth at that time. You should protect the interests of your parents and spouse first. Update all your nominations in investments, insurance. If nomination is not there, then nomination should be done. If nomination has expired, nominee has expired, then nomination should be updated. And as far as possible, nomination should not clash with will. Though nominee is a custodian only, and the real owner is according to the succession laws. But nomination should not generally clash with the will, otherwise disputes will be there. You may add name of your spouse as joint holder in various accounts, investments. So as such, there is no hassles there. And you should remove all your inconsistencies in your personal records, like if DOB is different, if name spelling is different. So it is always advisable to maintain consistency. Uniform Civil Code Article 44 of the Constitution of India says about this, because there are different laws as per different religions in case of marriage, divorce, maintenance, adoption, succession, and inheritance. What the government is planning, they are planning to bring this Uniform Civil Code. So one nation, one law. Maybe in the near future, time will tell whether it comes or not. Role of professionals. There are huge opportunities for the professionals, for chartered accountants. Whenever we have free time, because there is no deadline there. 30th September is not audit deadline. 25th of July is not any court hearing or any hearing for any appellate work. So whenever you are at ease, you can plan this. Maybe during the lean period after this December is over, you can plan, you can make list of your clients, A category clients first, whom you can approach, whom you can tell them. And there is no need of taking new clients. From your existing clients, you can earn very well. And it is for your own benefit as well as the benefit of your client and their family also. You are helping them, though you are earning, but you are helping the society also by this. And in case of any help required, maybe of an advocate, because some things are complicated, you can take assistance of any other professional as well in registration, in drafting. But I urge each and every professional, each and every practicing chartered accountant to add this opportunity in your armory, in your professional armory, as your professional vertical. Now, what is the best inheritance? The best inheritance is a father leaves for his children is a good example. We should always set a good example for our younger generation, for our children. And that's all from my side. I wish you all the best. And from the core of my heart, I am thankful to the Institute of Chartered Accountants of India for providing me this opportunity to share my views to the gathering of August professionals, August chartered accountants. I was also a chartered accountant in practice till 2015. And it's a privilege to be a part of CA family once again. Thank you. Thank you all.
Thank
Over
you.
to the organizers.
Thank you, Tanuj Agrawal ji. Very well said by you. There is no deadline. I think every day is deadline, sir, for this will. Because you said initially, kal ho na ho. So we are taking some questions from participants, sir. One person resident in India but have property bank balance overseas. Will Indian Succession Act be applicable or the local law of the country?
See, the Indian Succession Act will be applicable.
Okay.
But for that country also, if there are, because there are numerous countries there. So for that country also, if there is any formality to be required, that should also be done. And there should be consistency between both the countries. For example, in India, you are saying my first child will get all the properties. There also you should make nomination or you should execute some document. In case of my death, this child will get. If there is any conflict, then disputes will arise.
Okay. Next question is that what is the status of a girl child in a Hindu undivided family if she was not considered a co-partner before the Hindu Succession Amendment Act came into force?
See, with effect from 9th of September 2005,
5.
each and every girl child, whether minor, major, married, unmarried, she is entitled to the share in her father's HF.
Okay.
Condition is that if any partition has taken place, any written partition has taken place, and things were settled, that settled things will remain settled now, even after that amendment. And HUF must exist on that date. Father may or may not be alive. Honorable Supreme Court in the case of Vinita Sharma has provided these guidelines. Earlier, there were few other conflicting judgments of the Honorable Supreme Court, but now the law is settled after Vinita Sharma judgment.
Okay, bhai. Next question is, if a person died without any successor and made third person nominee for fixed deposit and third person received proceed of FD, after FD, what will be the tax liability in the ends? Like they are asking about the tax point of view. Ki who will be tax?
There are three things here with respect to the tax liability. Up to the date of death, the deceased is liable to pay tax.
Okay.
And after the death, and after till the date of distribution, there a separate PAN number has to be taken in the case of representative SSE.
Okay.
And the return has to be filed in that manner. The income is of that representative SSE will file return. And after the distribution takes place and things are materialized, after the beneficiary will take, the income will be taxable in the case of beneficiary. But one interesting point you mentioned here, that there is no successor and nominee is there only. So if there is no class 1 year, no class 2 year, no agnates, no cognates, and will is also not there, then the entire property will go to the government, not to the nominee. Nominee is just a custodian. Government can claim from that nominee.
Very well, sir. Remaining questions you have covered already, sir, in your topic. Thank you, Tanuj Agrawal ji. A sincere thank to your esteemed speaker enlightening us on the critical topic of succession planning. Thank you so much, organizers. Thank you so much. Jai Hind, Jai ICI.
Thank you.
Yes.
Hello? Yes, you can end this.